All right, we should be recording now. So welcome everyone. We've got 50 plus people on the webinar. This is our second webinar now. We did the first one on intellectual property and protections for small business. We've now got another 50 people on this webinar for the new unfair contract laws which came in over the weekend. Just a quick introduction. I'm Ian Aldridge. I'm the principal of Progressive Legal. Claire Mould is here coming live from Perth. I'm in Sydney from Bondi Beach. Claire's from Perth. So we've got the great new technology now to bring this stuff to you. And it's going to be a really punchy webinar, half an hour maximum, so we can let you get on with your day because we know how busy you are. So just kicking us off, if it works. Here we go. First of all, it wouldn't be a legal webinar without a disclaimer. So we just need to make sure that you understand what the purposes of the webinar is and in terms of questions and legal advice. So essentially, it's for general information purposes only. We're providing this information to you off our own bat to give you a heads up on what the new legislation will be. Because it's new legislation, we're not entirely sure completely how it's going to be interpreted yet. And because every business is different, we need to make sure that we tailor advice for different businesses. We can provide general information and talk to you on a high level about the changes and what we see as the implications, but it's not to be taken as specific legal advice. So if you want us to review contracts, or if you need to speak to us about specific advice on specific issues, please let us know after, and you can contact either myself or Claire and have a chat about your specific business. And we don't charge for that for our clients or people that we have on our webinars. All right. So Claire, do you want to take us through the changes? Oh, we can't hear you, Claire.
Oh, sorry. Can you hear me now?
Yep, that's fine.
Yep, great. All right, so look, there's three things that you're going to take away from today's session. And first of all, the first thing you'll take is an understanding of the changes to the Competition and Consumer Act 2010 and the Australian Securities and Investments Commission Act 2001. So we're going to tell you about what the changes are. Secondly, we're going to tell you what it means to your business, the effect that the changes are going to have on your business, and also thirdly, the likely consequences of the changes.
So the new laws that have come in, I won't bore you with the details. Here's the Act. If you feel like going and doing some more research, please do so. What's basically happened is there's been a lot of consumer law, as you might be aware, that's developed over the course of the last 50 years or so to protect consumers from bigger business with take it or leave it style contracts. And for small businesses, small businesses have been left exposed in a way unlike protections which have been provided to consumers until now. And it seems like this has been really heavily lobbied for quite some time. It's been in the works for a very long time. And thankfully now it's going to provide an increase in protection for small businesses against larger businesses that have take it or leave it contracts with them. But also, it's a double-edged sword for any small businesses or businesses doing business-to-business contracts. Then you need to be aware of these laws in great detail, because they'll affect your terms and also your dealings with other businesses as a result of those terms.
Can I just say one thing? For those of you who aren't too sure about what we mean when we say a take it or leave it contract, we're referring to contracts that, where the other party won't enter into any negotiation. They say, this is our contract, sign it, or, if you don't sign it, you can't play. So that's what we mean when we say take it or leave it contracts.
Yeah, good point. The new laws, as I said, apply to small business contracts, and they will only apply to contracts entered into or varied or renewed after the 12th of November, which has already passed. So if you've got contracts on foot at the moment, nothing will, the new laws don't apply to those unless, they are renewed or varied after this date. But certainly for all new contracts that have been entered into after the 12th of November, this legislation will apply. And one of the really important points that are sort of picked out from examination of this new legislation is that they apply to standard form contracts. So say, for instance, a bigger business has their standard form contract, and they say, here's our standard form contract, sign it and return it, essentially, and no negotiation is usually entered into with some of these larger businesses. And it doesn't really apply to any of these contracts that you negotiate the terms. So if you've negotiated the terms or discussed any of the terms in the contract, it seems as if, regardless of whether they change the contract or not, you may have basically contracted out of this legislation by negotiating the terms of another business's contract. And likewise, someone may have done the same for you. So you've got to always think of the corollary with this, especially if you're doing business to business, or if you're dealing with bigger business. So this is a really, really important consideration. We'll deal with this a little bit later, but what I wanted to flag was you may need to give some consideration as to whether you actually enter into negotiations about a contract if the only thing that's concerning you is a contract term which may ultimately be struck out by a court. So, but it might be a bit of, case-by-case basis whether you decide to raise these issues up front, or if you're going to be raising a whole bunch of issues about contract, then you might consider raising them all at once. But certainly it's all new ground. So this is what the definition of a small business contract is. The takeaway, and you can read this in your own time. We'll send out a recording of this webinar to guys. If you need to duck off at any stage, we'll be sending out a recording of the webinar, to everyone that's registered. So you can feel free to read this at your own pace. But essentially, if you've got fewer than 20 employees, or if the other party has fewer than 20 employees, then it's going to be a small business contract. Or if the upfront price of the contract doesn't exceed 300 grand, or the duration of more than 12 months and the upfront price doesn't exceed $1 million. Essentially, it's pretty much going to apply to most small business contracts. Claire, do you want to take through this?
Absolutely. So, what makes a contract unfair? Now, a contract is unfair if it causes a significant imbalance in the rights of the parties under the contract. And I always say to people, use the gut feel test. Obviously, that's not the sole test you should use, but if something feels unfair, it probably is. So, a contract is also unfair if it's not reasonably necessary to protect the legitimate business interests of the party advantaged by the terms. And the third test for unfairness is, would the term cause financial or other detriment to the party if it was relied on? So significant imbalance in rights and obligations, not reasonably necessary to protect the business interest, or would cause financial or other detriment if it was relied on.
And some good examples of clauses that might be considered unfair at law usually relates to, and as I said before, have a read of these at your own leisure. But where you've got one party but not the other, giving rights or abilities to renew or vary or terminate or penalise one party, and that not being mutual, then it seems like there's you know, there's going to be probably an onus of proof borne by this party relying on the clause to prove that it's not fair, as opposed to the other way around. And you know, businesses have sort of prided themselves, and also lawyers have prided themselves for, you know, on behalf of businesses, about drafting contracts which are very one-sided in favour of the business that's supplying the contract. And now it seems as if, you know, contracts are going to really have to be drafted with this in mind, to make sure that these provisions don't fall foul, because if they do, they'll be struck out by a court, or they'll get a complaint investigation that they have to answer to by ASIC or the ACCC. So I would imagine that a large amount of big businesses now reviewing their contracts for this same purpose, and business to business businesses are going to have to review them as well. So anywhere where there's some sort of limit on one party's liability or rights, yeah, it's going to seem like the contract is going to be unfair. And with one.
Oh, sorry, I was just going to say, often we'll see, just by way of example, we've mentioned termination provisions. Often we'll see a termination clause that says party A may terminate this contract on 7 days' notice, but there's no equal provision for party B. That's the classic unfair term. Also, indemnity provisions. Party A agrees to indemnify party B in respect of all losses, blah blah blah. But there's no reciprocal indemnity clause in favour of party B. Again, a classic unfair term. So it's just those unilateral rights that you need to really look out for.
Yeah, and look, you know, in some circumstances, perhaps it might be necessary, but you know, I think businesses are really going to have to look at their contract provisions carefully to make sure they're not going to fall foul of this legislation. In terms of what it means for you as a business owner, there's, as I've sort of mentioned before, this double-edged sword. So either when you want to enforce your terms against another business, or when a business is trying to enforce their terms against your business, you really need to be alive to all these issues that are now going to be changed as a result of these laws. And as I've sort of alluded to, you can either use it as a shield or a sword in these, you know, and of course, mainly we imagine the only time this is going to really arise is when terms are going to be enforced, or at the initial outset of negotiations in the contracts to begin with. What you will classically find, I think, and we can only sort of predict with a crystal ball at this stage, but we imagine that there is going to be a lot of scope for parties to attempt to get out of certain parts of a contract, or even contracts altogether, by alleging that there will be some terms in the contract which will be deemed by a court or ASIC or ACCC to be unfair, and therefore struck out. And even the prospect of having court proceedings being raised will potentially be enough for some parties to let other parties out of the contract as a result. And certainly when they get legal advice in relation to some of these contract provisions, we can definitely see that you know, we're going to be giving some legal advice to clients about, well, look, this term is going to be considered by a court as unfair. It's going to be struck out. If you go to court, you're probably going to have to pay the other side's costs of doing so, unless you unless you either let them out of the contract or say or agree that this term is not going to be enforced. And what we'll probably see as well is a number of defences to any enforcement proceedings with threat of complaint or complaint to ASIC, ACCC as well. And ASIC and the ACCC have been allocated, I think it's about $1.5 million to, to assist with this initial process. I don't know how long that would last, and depending on how much, these new laws are used, I can't imagine it going very far. So it may well be that complaints are made to ASIC and the ACCC. A letter is sent out to the party that's been complained against, essentially saying, please provide us with a copy of your take it and leave it terms, and then they will determine or potentially commence their own court proceedings against a business for having to change these terms in the contract. That's what we can sort of see so far, and of course, history will unfold. Claire, do you want to take over?
Yeah, absolutely. So in terms of action, so from now, you should really review and check all of your standard form contracts that not only you've drafted, but contracts that you've signed, drafted by other parties. Do they have any unfair contract terms in them? Check your termination provisions, check your indemnity provisions, check your renewal provisions. And then if you do find any unfair terms, think about what are the risks in these unfair terms. As I said, yeah, use the gut feel test. If something feels like it's unfair, it probably is. You've got more rights now. So if you feel that you're in a position that's unfair, then now you can speak up.
And certainly those sort of provisions, if obviously you're not going to have time to go through all your contracts, but maybe really major ones that you've got with suppliers or anyone's entered into after this date, then I'd also be looking at, have a look at the termination provisions, the really sort of big ticket items, indemnity clauses, rights and obligations, any of those main sort of big ticket items where you think, okay, this is a really important provision. Is it one-sided, or is it two-way? And then have a look at it from there. Or we can review your your terms and conditions, or important contracts that you've got as well if you don't have time.
Yep. And in addition to reviewing the contracts that you've got on foot at the moment, if you're in the process of negotiating some contract terms, go into that negotiation now armed with the knowledge that you can't be treated unfairly.
At law, there's laws now to protect you as a small business, against other small businesses and against big business, to allow, to give you some of these rights, just like as if you were a consumer, essentially.
Yep.
I think we've gone through a few of these, but these sort of unilateral rights to terminate, here's sort of examples: to terminate or suspend services, absolute discretions, etc.
Yeah.
And here are some others as well.
Yeah, classic examples.
And being able to, change or update terms and conditions at any time without, prior notice, etc. They're going to have to be bolstered somewhat in terms of fairness, not just on one party not being able to, do something against another. They're sort of classic, but there's also going to be, unfair contract terms in terms of the ability of one party to just do something. There may be something read into contracts about, what's going to be able to stick in terms of, a good example is the first one here. Really sort of making it a lot more fair on the other side, to give them some rights. We also don't know what's going to happen with entire agreement clauses as well. It's going to be something which is going to be interesting to see. So usually entire agreement clauses state that nothing outside the contract exists. So say, for instance, warranties or discussions prior to, oh yes, we'll do this by this date. but because it's not in the contract, and the contract says, everything is in this contract, nothing outside, is to be considered, then perhaps entire agreement clauses as well will be under attack, and obviously we'll probably see some case law about that in due course. So we hope that today has given you a bit more information about what the implications of the new small business unfair contract legislation is, as well as giving you a bit of background about where the law has come from, where it is now, and where we think it's going to go. We wanted to provide a really punchy webinar today. I know we're sort of at 20 minutes now, just to kind of give you those broad strokes, and we'll probably do a follow-up webinar on this in due course for any changes that we see with this legislation or a case law as a result. What I wanted to do today was give you sorry, say that again?
I was just going to say, or any questions that if you, after this webinar, go away and have a look at some of your contracts and you're unsure about any particular clauses, feel free to let us know and we can give you our opinion.
Yeah, one thing we've really noticed as well is, well, at least in Australia, it's very, very difficult for small business owners to find out what the relevant law is, how it's going to change. Even if they find stuff that's been presented by lawyers, it's usually very legalistic or esoteric, or talking about sort of fundamentals or things that they're not really interesting to a small business owner. It doesn't help them decide, okay, what are the new changes? How is it going to affect me? And what do I need to watch out for? Do I need to do anything right now? And what can I do in the future? We're going to be doing our webinars so that they're really punchy for small business owners, to give them practical, honest, transparent, and open advice about what all this is, what the law is in Australia, and how does it impact you as a small business owner. And just leading into that, this is why we're creating Law in a Box now. It's going to be launched in the next week or so. And what I wanted to do for those people that have registered for our webinars, what I'll do is I'll give them a free access to Law in a Box, which I think is going to be priced around $500 for the year. But I'll give everyone that's registered free access to it, which essentially contains a whole host of legal information for small businesses and startups. We're really excited about the launch in the next week. It's currently being built in the background at the moment. That contains a whole host of information about those sort of major areas of law that affect a small business owner, and
property.
Yeah, all those sort of things like intellectual property, contracts, these new unfair contract provisions, for example, workplace law, some tax law, social media, all this stuff. There's about probably 10 boxes, 12 boxes at the moment, and we'll grow them. But it's basically going to be a bit of a hub, a practical hub containing articles, frequently asked questions, case studies de-identified, some video content, webinars like this. So it's going to be, free content for those that we decide to give away to. So we're really happy to extend that offer to you as a bit of a thank you for being the first on our webinar series, and being first to check us out. I was going to say as well, if you want to have a look at, if you want to go to progressivelegal.com.au, you'll find on the Legal Shield pages, on the Legal Shield page, a list to our other products: Law on Demand, Seed, Grow, and Scale. Essentially, these are products that we've released to help small business owners amortize their legal costs over the course of a year by easy monthly payments. Law on Demand includes Law in a Box, but also it includes access to us as and when you need us for $150 a month, including GST. You can call Claire.
148.
Yeah, 148. You can call Claire or myself, or email us and ask those questions like, can you just run your eye over this email real quick? It's got a legal flavour to it. What do I need to do? We get to know your business really well. We'll give you a strategy call to go through your business and give you some advice about what you might need to watch out for. That's complimentary. And then you get us as a resource actively, on call essentially as and when you need us. And there's no lock-in for that. Just pay by the month. So that's Law on Demand. And then Legal Shield, Seed, Grow and Scale. We've worked out that all small businesses need probably some tailored documents. So we've just sort of clumped businesses into these three categories, depending on the level of service you need and the amount of documents that you need tailored for your business. So a seed business, everyone needs their terms and conditions, privacy policy, disclaimer, waiver, or something else for their business just to get off the ground. A growing business perhaps is employing staff, needs a trademark as well, or a scale business is usually a business that has got multiple business owners, so needs a partnership agreement or a shareholders agreement, as well as, either a partnership agreement or a shareholders agreement and 6 other documents. So the seed has 3, the grow has 5, and the scale has 7 tailored documents for your business. Nothing is off the shelf. It's all tailored for your business. And you get a lawyer that is, both of us, which is going to be at your call as and when you need us for legal advice in a timely manner. And you don't have to worry about how much is this email going to cost, or am I being charged for this phone call. And if you join any of the packages, Seed, Grow or Scale, we'll do something else for you, throw in a free trademark or an incorporation unless the government charges, or if you need another document, we'll be able to basically put you on a lower package and give you that document for free. So anyway, I just thought I'd extend that special offer to you guys for being on the webinar. I know that a lot goes into these webinars. We obviously prepare a lot for them, and you only see what the final presentation is, but we're going to be doing a lot more of these to provide valuable information and content to other small businesses in Australia. So if you feel that other people can benefit from this as well, please let us know. Word of mouth referral is so big in our business, so we understand that. And hopefully we're going to change the way that small businesses get legal services in Australia. We're obviously, on the pioneer wagon to do so. So from Claire and me, we're under half an hour, so we'll let you go now and keep going with your day. Hope the lead up to Christmas is good. We may not see you before Christmas, but if we don't, have a great Christmas and a great break with your family and friends. And hopefully the summer is, as it is now, well and truly underway.
Indeed.
All right, guys. See you later.
Bye.